perform the same job duties deserve to be paid the same bonuses. What this hearing has established is that the HDEMs, the heavy duty equipment mechanics, work for the same employer. The HDEMs at Harbor and the HDEMs at LAWA, those are two departments within the city of Los Angeles. The employer is the city of Los Angeles. And what the evidence has established is that those two groups of employees, they both work for the same employer, city of Los Angeles. They both have the same job class, the 3743, and they both perform the same duties. Yet there is a dichotomy. You have one group of employees at Harbor who are getting salary note F on a pensionable basis, such that it's applied to their hourly wage rate, and it gets credited towards their pension. And then you have a second group of employees who have to record it daily, don't get it on a pensionable basis, and if they do not record it daily, they don't get salary note F. That is an arbitrary result that should support sustaining the grievance that the group grievance filed today. But Madam Arbitrator, there are three reasons that I want to outline for you about why the union should prevail in this particular case. Number one, I'm going to talk about the plain language of the MOU. Number two, I'm going to talk about principles of reason and equity as recognized by El Curry and El Curry and other arbitrators. And number three, the evidence that we heard from the city of LA today during their case in chief fails to rebut any of the evidence presented by the union. So I'm going to start with number one, the plain language of the MOU. So under the plain language rule, if the words are plain and clean, conveying a distinct idea, there's no occasion to resort to interpretation, and their meaning is to be derived entirely from the nature of the language used. So with that as the beginning principle, let's take a look at salary note F. You have it here, and you've seen it repeatedly throughout this hearing. But the evidence shows by Union Exhibits 1 and Union Exhibits 2 that the language that I'm highlighting here at the very bottom, pensionable when regularly assigned, non-pensionable when assigned on a daily basis, showed up for the first time during the 2015 MOU. And prior to it being added to this language, there was no distinction between what was pensionable and what was non-pensionable. What the addition of this language did is it created a bilateral scheme, whereby if you are regularly assigned to perform repairs and maintenance on lift equipment, then you get it pensionable, meaning you get it built in, factored into your hourly wage rate. If as Ms. Gutierrez testified, if it's non-pensionable means that it's seldom done, that it's done on, in her words, on an as-needed basis. And here, if it's done during any part of the day, then you get it on a non-pensionable basis because it's not regularly assigned. And we had testimony about how within this particular note, the welders is one such classification. They seldom do it, and so to the extent that they do, they record it, and it gets awarded on a non-pensionable daily basis. So it's a bilateral scheme. Now, before we talk about what's disputed, I want to talk about what's not disputed. What the city of Los Angeles does not challenge. Number one, they don't challenge the definition of pensionable and non-pensionable that I just gave you, and I lay it out here in this PowerPoint. They don't challenge those descriptions, and Ms. Gutierrez, even on cross-examination, admitted that that's her understanding as well. Number two, they don't challenge the language in salary note F that the words two premium levels above the appropriate step rate on the salary range equals 5.5% increase. We had Mr. Froilan Zuleta testify that. We had Mr. John Sampson testify that. But there's no dispute that it means a 5.5% increase. And finally, there's no dispute that heavy-duty equipment mechanics perform repairs and maintenance on lift equipment. I'm going to get into the dispute over what the term lift equipment means for the purposes of salary note F later, and I'm going to get into what regularly assigned means, but there's no dispute that it is an essential function, an essential task of heavy-duty equipment mechanics to perform repairs and maintenance on lift equipment. All these things are not disputed. So what is in dispute? It comes down to really two issues, Madam Arbitrator. Number one, what is the meaning of regularly assigned? And number two, what is the meaning of the term lift equipment? So let's take the first one, the first topic first, regularly assigned. As you know, Madam Arbitrator, one of the first things in these cases of contract interpretation is to simply look at the plain meaning as defined by the dictionary. And what I laid out here on this slide is the definitions according to Merriam-Webster of the terms regularly, regular, and assigned. So I looked up the word regularly, and it simply means in a regular manner on a regular basis. And if we look up the word regular, it means constituted, conducted, scheduled, or done in conformity with established or prescribed usages, rules, or discipline. Another way to look at it is it's orderly, methodical, recurring, attending, functioning at fixed, uniform, or normal intervals. And I like the example here, regular churchgoer. Church typically occurs only, Sunday Mass occurs on Sundays. If I go to church every Sunday, that makes me a regular churchgoer. I don't have to go to church every single day, every single hour of the week to become a regular churchgoer. I have to attend on the interval, normal interval in that instance of once a week. Now, assign, verb, means simply to appoint as a duty or a task. And on that note, it's undisputed that it is a duty or task, as I said earlier, that HDEMs perform repairs and maintenance of lift equipment. So let's talk now. So let's break down each of those terms, regularly and assigned, starting with assigned. So HDEMs at LAWA are required to perform the tasks and duties of repair and maintenance on lift equipment. And even though, again, I said it's undisputed, here's the evidence that we have shown as part of our burden. On the HDEM task list, which you can find on page 20 of the union exhibits, under the maintenance and repair header, it says that HDEMs overhaul and repair electrical, mechanical, hydraulic, and pneumatic systems on cranes, aerial equipment, construction equipment, motor sweepers, and components of the aforementioned systems and equipment, including heavy lifting equipment. It is assigned, no dispute. But even further, on page 25 and page 29 of union exhibits, HDEM physical mental activity form, it lays out the essential functions, and that includes moving vehicles, heavy duty machinery and equipment, such as forklifts, tractor trailers, fire trucks, backhoes, all of which Mr. Stevenson testified have lift equipment either built into it or attached. No dispute that it's assigned. Again, class specifications, it just gives some examples. It includes repairs and lift devices. And then the competencies document, which is on page 35. The job requires knowledge of the principles and operational characteristics of power takeoff driven, PTO driven auxiliary equipment and their components and hydraulic systems in order to diagnose and repair a core component of the equipment. That core component is the lift equipment, which involves hydraulics and at times PTO-driven systems. Again, no dispute that it is assigned, and it's supported by the evidence. Now we get to the term regularly. Now, HDEMs, the evidence has established that they are required to perform and repair maintenance on lift equipment on a recurring basis at normal intervals. And what does the evidence show? Well, number one, the LAX fleet maintenance sheet. HDMs regularly use this sheet when performing preventative maintenance, also known as PM, or repairs. And then there's these repair codes of various equipment at LAWA that arrives in their shop. And that's on page 69 and page 70. And that includes needing to check the liftgate operation and PTO components, not on occasion or, seldom, but every single time. And for your reference, Madam Arbitrator, this is what I'm talking. This was the lift. These are parts of the exhibit involving that sheet. That is an essential core part, and that Superintendent Hess himself testified. They use these sheets on a regular basis on vehicles, and part of using these sheets is to check, in his words, quote, all aspects. That includes checking the liftgate operation and the PTO. Again, it is done regularly. And their witness concedes that by talking about how they need to perform preventative maintenance on a regular basis. Union exhibit number 17, the asset number master list. This was the list that Mr. Stevenson generated when he created an inventory of all of the LAWA machines and vehicles and equipment that have lift equipment on them and for which he needs to perform repairs and maintenance on. I note that there has been no rebuttal evidence presented to question the veracity and the authenticity of that list, that inventory that Mr. Stevenson himself gathered painstakingly. Only, and if you compare if you look at exhibit number 17 and look at the list of all the different types of equipment with lift equipment, there's only 15 HDEMs at LAWA compared to a huge volume of machines. So do they have to between the 15 of them, are each of them regularly repairing and maintaining these this huge volume of machines, devices, and vehicles with lift equipment? The answer is yes. And then there's the BIT program. This requires LAWA to inspect components of certain vehicles with lift equipment at fixed intervals. Again, on a recurring basis, normal intervals, every 90 days. And LAWA directs the HDMs to go above the minimum requirements of checking the brakes and the transmission. And Mr. Stevenson testified he has been directed that when he's doing the BIT program inspections, he needs to inspect the associated lift equipment for safety reasons. Again, that makes sense, but it's done regularly. And then the testimony of Fräulein Zulueta, he flags, you heard him, Madam Arbitrator, tell you, ever since he transferred to LAWA from the Harbor Department, which again, and I apologize if that wasn't clear, but those are two separate departments. The Port of Los Angeles is the Harbor Department. It's located at the port, and Mr. Zulueta used to work at that department within the city of Los Angeles. He then transferred to another department within the city of Los Angeles, LAWA, and when he transferred to LAWA, he started flagging the pay code daily. Why? Because he performs repairs and maintenance on lift equipment every single day at LAWA. Again, regularly assigned. Now, I want to note that we believe that frequency is not determinative of whether an employee is entitled to the lift bonus. We don't believe that the language supports the notion that you have to do it every single day in order to get the bonus. You'll already heard testimony that from Mr. Samsing that he, while at Harbor, because salary note F there is paid on a pensionable basis and it's built into the hourly wage rate, even when he's sick, even when he's on vacation, and even during the 3 days a week when he typically does not maintain or repair lift equipment, he still gets salary note F. That being said, even though we do not believe that frequency is determinative, on Union Exhibit 14, we presented timesheets that Mr. Zulueta fills out every week. And again, not rebutted, they're already in the evidence. And it's just, as an example, on page 64 of Union Exhibits, I highlighted it here for you, Madam Arbitrator. You can see every single day he recorded hours under the lift code bonus. And that's Union Exhibit 14. So So then we get to the second issue about, well, first of all, that covers that first meeting. We believe that we believe that the evidence has established that the employees are regularly assigned to perform and maintain lift equipment. So now we get to the second issue. What is the meaning of the term lift equipment?
Well, before we get to that,
Sure.
let me ask you a question.
Sure.
If a single HDEM, like Mr. Zuelta, regularly performs this work on the lift equipment, is it your position that all HDEMs at LAWA are entitled to it, or is it determined on an individual by individual basis?
No, our position is that it is not determined on an individual by individual basis. We believe that the salary note F only requires that you're regularly assigned. And again, we believe that based on their job description, based on the task list, based on the regularity with which they all need to do preventative maintenance and use the sheet and the bit inspections. Our position is that by virtue of you being an HDEM at LAWA, and by virtue of what's required of you as established by the task list, the job description, the competency requirements, you are regularly assigned to perform repairs and maintenance of lift equipment. And that what Mr. Zuleta is doing, while we submit that if it comes to frequency, he does it more frequently than say Mr. Stevenson, as you can see from his pay stubs, but that should not be a factor.
Okay.
Just as it's not a factor at the Harbor Department.
Okay.
Thank you. So now, do you have any more clarifying questions on that first point of contention of regularly assigned?
No, I just wanted to make sure I understood what your argument was.
Sure, thank you. So then we get to the second core dispute here, which is the meaning of the term lift equipment. Under Merriam-Webster's definition of lift, it simply defines it as any piece of equipment that raises material or persons from a lower to a higher position. And like I said, Union Exhibit 17, which is the list of equipment, machines, or vehicles with lift equipment at LAWA that Mr. Stevenson compiled, is uncontested, it's undisputed. And when it comes to Union and the photographs on Union Exhibit 21, Mr. Hess had some dispute over the extent to which salary note F applied to those particular machines, but he did not dispute that those vehicles, like the dump trucks that he looked at earlier, or the crane trucks, he doesn't dispute that those have lift equipment on them. So the city of Los Angeles's narrow definition of lift equipment, which you heard earlier, was based on this notion that it has to lift people, or it has to be designed. Actually, it's unclear to me if it has to be designed to lift a person, or if it's intended to lift an individual or personnel, a person. That rationale has no basis in the text of the MOU. The lift equipment that was designed to carry more than just people would not be considered under their rationale. Things like forklifts, even though they literally have the word lift in them, would not be considered lift equipment. Now, this contract between the city of Los Angeles and SEIU 721, they've had this relationship for decades. And the folks who drafted this agreement, these are sophisticated parties. They're well versed in the art and science of collective bargaining. And if they meant to limit the otherwise broad term lift equipment to only certain types, they could have just done so. And in fact, in other provisions, they did. And you saw me, Madam Arbitrator, ask Mr. Hess about Article 510H1, which has to do with hazardous conditions bonuses. And Mr. Hess was very familiar with it because it applies to individuals that he supervises. And in that particular provision, it expressly identifies hydraulic lift platform as the type of lift equipment that you need. And Mr. Hess agreed with me that a hydraulic lift platform is indeed lift equipment. And so, in short, if the parties had intended to limit lift equipment to only that which carries people or only lifts personnel, they would have been able to do so. The fact that they left it broad is indicative of their intent to, in fact, apply it broadly. Now, in January, a few months ago, arbitrator David Bouvet issued a decision in favor of the union that involved somewhat similar, not on point, but somewhat similar language. And in that case, it involved whether or not garage attendants at the LAPD Air Support Unit should get the bonus related to biohazardous pay and cleaning activities associated with biohazardous conditions. And what he said here is what he said in his what the company was arguing, or excuse me, not the company, what the city of Los Angeles was arguing was that it has to be based on frequency. Because the garage attendants don't do it every single day because it's seldom done, it has to, they shouldn't get the bonus because it has to be done on frequency. And what arbitrator Bouvet said was that the operative language, when regularly assigned to cleaning activities associated with biohazardous conditions, does not connote or require any particular frequency of exposure to biohazards to be eligible for the bonus. The ASU garage attendants have the same description as those in the motor transport unit. It was very similar in that we also had a comparator group where you had a motor transport people who were getting it, and then the air support people were not getting it. And what the arbitrator said was they at the air support may encounter fewer cleanups of biohazardous materials, but frequency is not addressed in the salary note. If frequency was an issue, the parties certainly could have defined it as they did in other salary notes. Likewise, if the lift equipment, if that was an issue, they could have defined it. If frequency was an issue, they could have defined it just like they did in other salary notes. Now, the union salary note F, our interpretation is also consistent with other salary notes that distinguish between pensionable and non-pensionable bonuses. And I encourage you, Madam Arbitrator, to look at all of the different provisions that are listed under the salary note. You can, A, B, C, D. I encourage you to look at all of them, and because you'll see that there's a pattern. The non-pensionable bonuses have additional conditions. Sometimes they involve a percentage of work shift. You have to work 50% of your work shift in order to get this bonus, non-pensionable. You have to work for each day that you work on this. It has to be, if it's a daily, if you do it on for that particular day, non-pensionable. And I gave you some examples: salary note U and salary note AA, just as examples. Whereas if you look at where the parentheses appear where it says pensionable, the pensionable bonuses do not have additional conditions beyond the fact that an employee must be assigned to a particular task to get the increase. And again, by way of example, you can look at G and H, and I listed them here for you. But there is a pattern. And for us, salary note F, there's a bilateral scheme here. So if it's regularly assigned, then it's pensionable. And the language that establishes that this is non-pensionable is in salary note F. There's a phrase there that says, or when assigned to perform such duties during any part of a day. That is what makes it non-pensionable. If it's, as Ms. Gutierrez said, if it's as needed, if it's seldom during, just that part of the day, it's non-pensionable. But if it's regularly assigned, recurring, normal intervals, if it's inherently part of your job, if and when it's needed, you have to do it, then it's regularly assigned and it's pensionable. So that's our argument with regard to plain language. Now, with regard to the second part of our reason why we believe you should sustain the grievance, reason and equity. Now, in the citation here in Al-Curry, it said, an arbitrator should not overlook the equity aspects surrounding the grievance, which serves to guide her in making for a proper and fair interpretation of the language embodied in the contract. Another way to put it is the employer's actions may not be arbitrary, capricious, discriminatory, or unreasonable. Now, I introduced evidence of testimony from two employees who work or who used to work at, one of them currently works there, at the Harbor Department, the Port of Los Angeles. And, during my rebuttal examination of Mr. Stevenson, you would ask Mr. Stevenson about, what was the reason for the arbitration if you were already getting these codes and there was, as long as you input them and you'll get them, why pursue this arbitration? And the simple reason is this: to accomplish the goal of equity. At the Harbor Department, they receive salary note F as a pensionable bonus. They don't have to flag it daily. And because salary note F is built into their hourly wage rate, they receive it when they're on leave, when they're sick, when on their vacation, and on days when they don't even maintain or repair lift equipment. And you heard Mr. Sampson testify today that 3 days a week, generally, he does not maintain or repair lift equipment, but he doesn't have to worry. He still gets his bonus. And I put here for ease of your review on Union Exhibit 8, that's Mr. Sampson's paycheck. And before the bonus, before his efforts at advocacy as a union steward through the Joint Labor Management Committee that you heard about, he was only making $47.50 an hour. After his efforts, his hourly wage rate went up to $49.61. We believe, as a matter of equity, that should also be occurring at LAWA. And LAWA's arguments that they are somehow, because they are a separate department, they can somehow do it differently, it's unsupported by the MOU. There's no language in the MOU that says they get to do it their way, and this other department gets to do it their way when it comes to a bonus. The fact is, the employer is the city of Los Angeles. And the fact that the employer, the city of Los Angeles, does it one way for Harbor, which makes a substantive difference in people's pay, and not deny that same benefit to another department, is arbitrary, it's capricious, and it's also discriminatory. Now, Harbor employees were also awarded retroactive pay going back to July 1st, 2018. And I put I believe it's Union Exhibit 9, but Mr. Sampson testified, or it's page 46 of Union Exhibits, that he got $50,000 in back pay because the Harbor Department realized, it came to their senses, that they should have been paying these folks on a pensionable basis. And Mr. Zulueta, also on page 60, he got $11,000. Again, the employer's actions may not be arbitrary, capricious, discriminatory, or unreasonable. And they are being unreasonable by not doing the same thing here at LAWA. And I told you in my opening argument that there would be no better illustration of this lack of equity than Mr. Zulueta. He transferred to LAWA because he wanted to spend more time with his family. He wanted to have a better commute, an easier commute. We all live in, or actually, you don't live in Los Angeles, but if you did, you would understand there's so much traffic. And so he was able to transfer because he wanted to spend more time with his family. And the way that he was rewarded with that transfer was with a pay cut. Ms. Gutierrez testified that people are supposed to come with the same base rate. And there was a dispute. We went back and forth on whether or not that base rate should include bonuses or not. But for practical purposes at Harbor, his base rate was higher than the base rate that he ended up at LAWA. That is an inequitable result that should not occur within the same employer, the city of Los Angeles. And Zuleta was making $47.15 per hour. And after his transfer, his base rent went down to $44.69. That's an inequitable result that, and one of the other reasons why this grievance is being pursued. This should not be happening like that within the same employer. Now, then today we heard finally from the city of Los Angeles. They have failed to rebut the union's evidence and the union's case. First, in 3 ways. Number one, LAWA's interpretation of lift equipment as applying to only lift equipment that lifts people, it's flawed, it leads to absurd results, and it's unsupported by the evidence. And then number two, LAWA does not dispute the meaning of pensionable and non-pensionable. They only dispute the extent to which one applies, but they don't dispute the bilateral scheme that's found in Salary Note F. And then number three, Superintendent Hess testimony actually supports the union's view that HDEMs are regularly assigned to perform repairs and maintenance on lift equipment. So I'm going to go through those 3 points right now. So number one, LAWA's interpretation of lift equipment as applying only to lift people. First and foremost, nowhere is that found in the MOU. Again, these MOU drafters are sophisticated parties. They could have specified it. They purposely left it broad. There is no qualification with the otherwise broad term lift equipment. And if you look on Joint Exhibit page 40, as I had said earlier, that particular bonus related to hazardous pay is specifically tied to only hydraulic lift platforms, which Hess testified is a form of lift equipment. If the drafters wanted to be that specific in Salary Note F, they could have done so. The fact that they did means that they intended it to be broad. Number two, it's not written down. You heard me ask Mr. Hess from the get-go that his job was to enforce policies and rules, and that those policies and rules, he agreed with me, they need to be clear and unambiguous. And that is especially the case when it comes to people's pay. And it's important that you write down policies and that you distribute them, because if you don't, then people are just going to think that they're making up rules as they go along. Well, that's what happened here. It was not written down. And they are making up the rules as they go along. There's this notion that it only lifts people. It was communicated for the first time to the employees, to Mr. Stevenson, 3 months ago. 3 months ago. This is a post hoc rationalization that they came up with to try and defeat this grievance. But there's no evidence of it being written down, it being ever announced at staff meetings, nothing. And then, of course, we get to the alleged communications with the CAO's office. And the CAO's office, you heard the testimony today, according to the witnesses, is the office that is ultimately that they go to when they need advice on how to interpret certain provisions of the MOU. And so here's what we heard today from Mr. Hess. He said that he heard from somebody in upper management or HR who then talked to somebody from the CAO's office that the term lift equipment means only lift people. But Mr. Hess did not communicate directly with the CAO's office. Who did he communicate with? Well, that's Minerva Gutierrez's job. She is the liaison to the CAO's office. She is their HR person. She's the person responsible for enforcing all the bonuses related to the MOU. And what did she testify today as the person who everybody, including Mr. Hess, relies on for input on how to interpret language? She testified she never talked to the CAO's office about Salary Note F. No conversation. And she testified she was never at the bargaining table when Salary Note F was ever discussed. There's simply no evidence that the CAO ever stated that every department gets to decide what qualifies as lift equipment. It's unsupported by the evidence, and in any event, it's hearsay. These are out of court statements offered for the truth of the matter asserted. There's nobody from this. What they should have done is they should have had somebody from the CAO's office come in here and testify about what it means, how it should be interpreted. They could have had a chief negotiator or somebody who was at the bargaining table come in here and say, you know what, Madam Arbitrator, actually during the conversation, I remember that conversation about pensionable, non-pensionable, and here's what was communicated across the table. Nothing. All we have is hearsay and one person, unnamed person from the CAO office saying this to another unnamed person who then ends up with Mr. Hess, only to then realize that Ms. Gutierrez never actually talked to the CAO's office about salary note F. It's unsupported by the evidence. And more than that, Hess's rationale leads to absurd results. He says that forklifts, which have the word lift in it, is not lift equipment. That's not supported by any of the evidence, and it's not supported by the lived experience of the HDEMs at LAWA, like Mr. Stevenson and Mr. Zulueta. Now, for the most part, Mr. Hess's testimony actually supports our view about what is regularly assigned work. He testified on direct examination, and I wrote it down in my notes, and I put it here for you, as part of their regular duties. Those were his words. HDEMs, heavy-duty equipment mechanics, perform PMs, preventative maintenance, and bit inspections. And on cross-examination, when I asked him about PMs and lift equipment, and whether or not, as part of the preventative maintenance process, which they do on a regular basis, do they have to repair and maintain lift equipment? And he said that they have to look at all aspects. Those were his words, all aspects of the equipment. And that includes the lift equipment. And that's that portion of that yellow page in my earlier slide that says check lift gate. And adjacent to it is that box that talks about PTO. The bid inspections, he agreed that they occur every 90 days. That's a recurring basis. He said that it could be done any time that a bid inspection is required. Again, if and when it is required, that is inherently a part of the job duties and tasks of the HDEMs. And Ms. Gutierrez said that the non-pensionable distinction, in her words, means as needed basis that seldom occurs. PMs and bid inspections, as Mr. Hess said, they occur all the time. So that's a recurring basis. And I put here, you can also recall the testimony of Mr. John Sampson. And he provides us with an explanation, because we keep talking about pensionable and non-pensionable. Well, here it is. The non-pensionable language applies to classifications like welders. And you heard him testify, and I believe you actually asked him questions about this. And he told you, yeah, well, welders, they seldom do it. But when they do, they are entitled to salary note F. And by the way, also, there's that other category, machinists. We have not talked about the machinists, and they're not part of this grievance. But the machinists at Harbor, because they perform maintenance and repair, and they're regularly assigned to do it, they also get salary note F as pensionable, whereas the welders non-pensionable because it's seldom done. Now, ultimately, having heard now what the city of Los Angeles' argument, LAWA, it comes down to this. LAWA wants to get a pass. They want an exemption from salary note F. This exemption is unsupported by the MOU. It's unsupported by any arbitral authority. It's unsupported by reasons of equity and the interest in precluding discriminatory, arbitrary, and capricious application of policies. And their witnesses simply did not provide any substantive evidence to warrant them getting a pass, them getting an exemption, them being able to interpret Salary Note F in whatever way they see fit. It's simply unsupported. And for these reasons, Madam Arbitrator, and for the main principle of the plain language of the MOU and the principle that employees who work for the same employer, who have the same job class, perform the same exact job duties, that they deserve the same bonuses. Under those principles, we ask that you sustain this group grievance. And we ask specifically in terms of a remedy, what we request is that you issue an order and an opinion and award that includes the following. Number one, sustaining the grievance. And then specifically number one, make whole relief for all LAWA HDMs starting from July 1st, 2018, which, as I want to remind you, was the effective date of the MOU that was operative at the time that the grievance was filed, all the way to the present. That's number one. And then number two, for the former LAWA HDEMs, maybe people who retired in the last year or so, we want them made whole for the time between July 1st, 2018, and when they left LAWA. And I just put here as a citation, our arbitrator David Bouvet decision, he crafted that particular remedy, and I just put it here as an example that you can reference. And number three, we want the current LAWA HDMs who started at LAWA after the December 2021 grievance was filed, we want them to be made whole from the effective date of their transfer or start with LAWA to the present. And again, I cited the Bouvet decision, which he crafted a similar remedy. And then number four, we just request that you retain jurisdiction should any issues arise if you decide to issue us an award and sustain the grievance. And with that, Madam Arbitrator, if you have any questions, I'm happy to answer them.
No, I'm very good. Thank you very much. Well done.
Thank you. So do you want me to email this to you as, do you want me to PDF it or just send it as a PowerPoint and PDF?